My name's Graham Tong and I'm a licensed conveyancer and associate partner at Boys & Morn. I've been a conveyancer since 2012. In my first podcast, I gave tips on how to get ahead before you start the conveyancing process. In this podcast, I'm going to talk about how to navigate a leasehold sale or purchase. Leasehold conveyancing is usually more complicated than a freehold transaction and has more potential pitfalls. To ensure a leasehold transaction is as smooth as possible, buyers and sellers need to understand the extra moving parts. A leasehold sale or purchase usually involves not only the buyer and seller, but also the landlord or freeholder, the managing agent, sometimes a management company, and where there's a mortgage, the lender as well. According to a recent government estimate, there are around 5 million leasehold homes in England, mainly flats. So whether you're thinking of buying a leasehold property, selling one, or you simply find yourself in a chain involving a flat, it's worth knowing where the common issues arise. So what does it mean to own a property on a leasehold basis? In short, leasehold is a form of legal ownership for a specific period of time. The terms of that ownership are governed by a legally binding document called a lease. The person who grants the lease is usually known as the landlord, and the person who owns the lease is known as the tenant, lessee, or leaseholder. Typically, leases last for at least 99 years when first granted, although common lease terms include 125 years, 250 years, or even 999 years. There's no standard template for a lease. Some are relatively straightforward, others are lengthy and technical. But the key point is this: the lease is not just background paperwork, it's the rule book for the property. It tells you what you own, what you don't own, who's responsible for repairs, what you can and cannot do, how the building's insured, how costs are shared, and what happens if the rules are not followed. When acting on a leasehold purchase, one of the first things a conveyancer will look at is the lease itself. The lease should describe the property by reference to a plan, and it should make clear whether the buyer is acquiring only the internal parts of a flat, or whether other areas are also included. For example, does the property include a parking space, a garage, a balcony, a garden or loft space? If so, is that area actually part of the leaseholder's property, or is it simply used under a right granted by the lease? That distinction matters. If a parking space is part of the lease, the leaseholder may have stronger rights over it. If it's simply a right to park in a particular area, the wording needs to be carefully checked. The same applies to rights of access, rights to use bin stores, bike stores, gardens and other shared facilities. The lease will also set out restrictions. These can cover things like keeping pets, subletting, running a business from home, laying wooden flooring, making alterations, replacing windows, installing a satellite dish, or using the property for anything other than private residential occupation. These restrictions are not always deal breakers, but they need to be understood before contracts are exchanged. A common misconception is that because you own the flat, you can do whatever you like with it. With leasehold property, that is usually not the case. You own the leasehold interest, but your rights are defined by the lease. If the lease says landlord's consent is needed for certain works, then that consent should usually be obtained before the works are carried out. One of the biggest issues in leasehold conveyancing is the length of the lease. The shorter the lease becomes, the more it can affect value, marketability, and whether a buyer can get a mortgage. Under current rules, a key point is the 80-year mark. When a lease has 80 years or less remaining, the cost of extending it can increase significantly. This is why buyers and sellers should check the lease term early. Ideally, a buyer should ask the seller or the estate agents before making an offer. If a lease is short, it may be necessary to consider a lease extension before completion, or to agree how the issue will be dealt with as part of the sale. Lease extensions can cost thousands of pounds, so it is not an issue to take lightly. It is unlikely that the lease can be extended quickly or automatically. Take advice at the start, because a short lease can affect the buyer's mortgage offer and the seller's ability to keep the transaction moving. Another key issue is ground rent. This is a regular payment made by the leaseholder to the landlord under the terms of the lease. In some leases, it is a very small amount. In others, it can start at a relatively low level, but increases over time. The problem is not always the amount payable today. Sometimes the issue is what the lease says will happen in the future. For example, ground rent that doubles at regular intervals may look manageable at first, but it can become problematic over time and make lenders nervous. I've seen ground rent that doubled every 10 years and rose to more than £1 million per year before the end of the lease term. So it's essential that the conveyancer checks how much is payable, how often it's paid, when it increases, and whether the review mechanism is acceptable to the buyer's lender. That's why ground rent clauses are reviewed carefully, even if the current payment seems modest. Service charges are another major part of leasehold ownership. They're usually collected to pay for the repair, maintenance, management and insurance of the building and any communal areas. This can include cleaning, gardening, lighting, lift maintenance, roof repairs, external decoration, management fees, accountancy fees and buildings insurance. When buying a leasehold property, it's important to look beyond the headline monthly or yearly service charge. The buyer should understand what the charge covers, whether there are arrears, whether the accounts are up to date, whether there's a reserve or sinking fund, and whether the managing agents are expecting the costs to rise. A low service charge is not always good news. It may mean the building is inexpensive to run, but it may also mean there is no meaningful reserve fund, and major repairs could result in large one-off demands. Equally, a high service charge is not automatically unreasonable if the building has lifts, extensive communal areas, gardens or complex maintenance obligations. The important points are that the cost is understood, justifiable and affordable to that specific buyer. Some mortgage lenders set a maximum percentage in terms of the service charge in relation to the property value, meaning that they may not lend on properties with disproportionately expensive service charges. Buyers who are relying on a mortgage need to be aware that a high service charge for a low value property is unlikely to be acceptable to a lender. Major works can be one of the most crucial practical issues in a leasehold transaction. These might include roof works, window replacement, lift repairs, external decoration, fire safety works or cladding related works. If substantial works are planned, the buyer will want to know what they are, when they're likely to happen, how much they may cost and who will be responsible for paying. You may hear the phrase Section 20 consultation. In broad terms, this is the consultation process landlords usually have to follow before carrying out certain qualifying works or entering into certain long-term agreements where leaseholders will be asked to contribute £250 or more. If a seller has received a Section 20 notice or knows major works are being discussed, that information should be disclosed early. I've seen sellers who have been pressured by their buyers to reduce the sale price by many thousands of pounds due to upcoming works. It can be a huge concern for buyers and mortgage lenders if a big contribution is due from the leaseholder. From a buyer's perspective, planned works can affect affordability. From a seller's perspective, failing to deal with the point openly can lead to delays, renegotiation, or even a buyer withdrawing. Sometimes the parties may agree a retention or allowance. A retention is where funds are held by the seller's solicitor after the sale is completed, and the buyer can draw on the funds when they provide an invoice for the works via the conveyancers. An allowance is where the sale price does not change, but the seller agrees to accept the sale price less an allowance sum from the buyer in order to complete the sale. Whether a retention or allowance is agreed depends on the circumstances and should be dealt with carefully by all parties. One of the main reasons leasehold transactions take longer is the management information. In many cases, the seller's conveyancer has to obtain a leasehold management pack, often including replies to standard leasehold inquiries. The LP1 form is commonly used to collect information from landlords and managing agents about matters such as ground rent, service charges, and insurance. The difficulty is that conveyancers cannot answer those management questions themselves. They're dependent on the landlord, managing agent, or management company. Some provide replies quickly, others take weeks or even months. There are usually fees for the pack, which typically range from around £200 to £600 or even more. Buyers need to be aware of hefty post-completion fees payable to the landlord or management company, which quickly rack up. Notices of transfer and charge, deeds of covenant, certificates of compliance or other post-completion requirements can result in costs of £1,000 or even more. So it's important to be mindful of this at the outset and budget accordingly. For leasehold sellers, my advice is to get organised as early as possible. Don't wait until a buyer has been found before thinking about the management pack. If the property is already on the market, speak to your conveyancer about ordering the pack straight away. It may feel early, but it can save valuable time later because a buyer's conveyancer can raise questions immediately. Another common issue is whether the seller has complied with the lease. This often comes up where alterations have been carried out. The lease may say that landlord's consent is needed before structural alterations, changes to layout, replacement windows, new flooring or other works are carried out. If consent was required but not obtained, the buyer's conveyancer and lender may ask for the position to be resolved. In recent years, building safety has become a much more prominent part of leasehold conveyancing, particularly for flats in taller or more complex buildings. Depending on the property, the buyer's conveyancer may need to consider fire safety information, external wall assessments, landlord and leaseholder certificates, and lender-specific requirements. Not every flat will involve those issues, but where they do arise, they can add time and complexity. Insurance also needs to be checked. In most leasehold flats, the building is insured by the landlord, management company or managing agent, and the leaseholder contributes through the service charge or a separate insurance charge. The buyer will usually need their own contents insurance, but the building insurance arrangements must still satisfy the buyer and any lender. So with all that in mind, what are my practical tips for buyers and sellers of leasehold properties? If you're buying a leasehold property, my first tip is to take the lease seriously. Read the report your conveyancer sends you. And if something is unclear, ask. Make sure you understand the length of the lease, ground rent, service charge, restrictions, repair obligations, insurance arrangements and any planned works. Do not assume that you can proceed without reading the lease simply because your conveyancer has reported on the main terms and has not flagged any concerns in an email or phone call. Ultimately, you need to understand whether you can comply with the lease terms. For example, bringing your dog to live with you in a flat when the lease imposes a strict ban on all pets is likely to lead very quickly to a dispute with the other leaseholders and the landlord. Secondly, think about affordability beyond the purchase price. Can you comfortably afford the service charge and ground rent? Is there evidence that charges are likely to rise? Are major works planned? If you're stretching yourself to buy the property, a large unexpected service charge demand could be a real problem. Thirdly, don't assume you can use the property exactly as you wish. If you want to let the property, run a business from home, install hard flooring, alter the layout or replace windows, check the lease before you commit. It's much better to find out before exchange of contracts than after completion, when you may have already made grand plans for the property. If you're selling a leasehold property, preparation is key. Leasehold sales often lose time because key documents are missing or because the management pack has not been ordered early enough. My practical tips for sellers are to instruct your conveyancer early, order the management pack straight away, find your lease, share certificate if applicable, any guarantees, consents from the landlord and accounts. Settle service charge arrears, disclose disputes or complaints early, locate licenses for alterations, be upfront about your service charge and ground rent payments, any planned works or management issues. The more information you provide at the beginning, the easier it is for your conveyancer to deal with inquiries from the buyer's conveyancer. If there's been a dispute with the managing agent, a complaint about service charges, unauthorised works, a missing consent or an issue with major works, it's better to disclose it early. Problems rarely improve by being discovered late in the transaction. A conveyancer's role in a leasehold transaction is to review the lease, raise leasehold inquiries, check the management information, report to the buyer and lender, identify risks and make sure the necessary notices, consents and post-completion steps are dealt with. We're not just ticking boxes. The aim is to make sure the buyer understands what they're buying and that the seller is able to provide the information needed to move the transaction forward. To bring this together, the lease needs to be understood, the financial obligations need to be clear, the management information needs to be obtained, and any restrictions, consents or plan works need to be dealt with properly. For buyers, the key message is do not focus only on the flat itself. Look at the lease, the building, the management arrangements and the future costs. It may look like your dream flat, but it could quickly turn into a nightmare if you suddenly need to sell the property soon after buying it and you overlooked a major issue. For sellers, the key message is get organised early, order the management pack promptly and be open about any issues from the start. If you do that, a leasehold transaction is much more likely to proceed smoothly and you're far less likely to face expensive surprises or avoidable delays. Thank you for listening, and I hope this has helped explain how to navigate a leasehold sale or purchase with a little more confidence.